to take to the podium.
Thank you, and good afternoon. My concern in this paper is to try to consider with you a number of different possible scenarios regarding the position of the unborn within the Constitution. And in particular, I'm anxious to try and help you to understand the legal and constitutional implications of what happens if Article 43.3 is A, retained in the Constitution in its present form, B, simply repealed and not replaced, and C, amended in some form. And in relation to each of those scenarios, the critical question that presents itself is, what will the extent of the power of the Oireachtas to legislate in respect of abortion be in the event that any of those positions represented the constitutional situation? To do that, I'm going to revisit with you very briefly some principles that you have considered and have been considered with you in earlier papers, and to look again very briefly at the present position of the unborn in the Constitution and some of the legal observations that were made prior to the amendment of the Constitution in 1983, which, as we'll see, may be of relevance in assessing what happens if, in particular, Article 43.3 were to be repealed. Now, it's been explained to you already, and I'm sure you're familiar in any event with it, but just perhaps to outline some headline aspects of our constitutional system. The starting point is that it is the Oireachtas which is given the function under the Constitution of promulgating legislation. The effect of the Constitution is to constrain the ability of the Oireachtas to do that in a number of different ways by a number of different means. One of the mechanisms by which the power of the Oireachtas is limited is the provision within the Constitution of fundamental rights. The courts are given the power within our constitutional system to police legislation and to strike it down if they conclude that legislation impermissibly interferes with the rights of citizens. In that regard, the Constitution provides for a large number of express rights: rights to property, right to liberty, the right of the citizen to life, freedom of expression, freedom of assembly, to name just a few. The courts have also, and this is important in the context with which you are concerned, implied rights into the Constitution. The courts have decided that although not expressed in the Constitution, there are certain fundamental entitlements of the citizen which are inherent within it, and it is the courts which deduce and give effect to those implied rights. And again, importantly for your task, the implied rights which have been derived by the courts of the Constitution include rights to privacy in general, rights to marital privacy in particular, rights to bodily integrity, and in certain circumstances, rights to autonomy, the right of a citizen to make his or her own decisions as to his or her own welfare and be able to give effect to them free from undue legislative constraint. Of course, the legislature is entitled to and regularly does impair rights guaranteed under the Constitution. But in order to do that permissibly, the legislature must have a good reason for interfering with a right. That reason can come in the form of broad considerations of the common good. It can come in the form of taking account of other competing rights. And the legislative restriction on a right must not be any more or go any further than is necessary to give effect to the objective. It's the role of the courts to make the decisions subtending those propositions. It's the courts which decide whether the legislature has gone too far in interfering with rights of citizens. It's the courts which decide whether the reasons for impairments are justifiable within the Constitution. And in doing that, the courts take account of a broad range of circumstances, including the nature of the right, its importance, and the particular justification which the legislature has for restricting or interfering with it. Now, those propositions are abstracted and they operate at the level of general principle. In relation to the unborn, the present position, as you all, of course, know, is that Article 43.3 provides express protection for the right to life of the unborn. It was inserted, as again you know, into the Constitution following referendum in 1983 and subsequently altered following subsequent referendum. But before 1983, the courts had given some consideration to what the constitutional protection of the unborn was in the absence of an express provision to that effect. And you will see in the paper, paragraphs 9 to 12, a number of statements made by judges in the course of deciding cases in which they had expressed the view that the right to life of the unborn was protected by the Constitution, although not expressly provided for therein. And perhaps the clearest and most emphatic such statement comes in the form of a decision, single judgment of the Supreme Court in the 1995 Abortion Information Bill, Article 26 reference, where the court said the right to life of the unborn was clearly recognised by the courts as one of the unenumerated personal rights which the state guaranteed in its laws to protect and, as far as practicable by its laws, to vindicate. Now, that meant that certainly there was a body of judicial opinion prior to 1983 that even though no express provision had been included in incorporated into the Constitution protecting the right to life of the unborn, that was nonetheless given effect to in a similar way to the manner in which other rights had been implied into the Constitution, although not expressly stated in it. But two important things about these statements. They were just that, statements. Lawyers distinguish between observations which judges frequently make in the course of deciding cases, where judges express a view as to how the law may develop, but which are not necessary to decide their cases. They distinguish between those statements and binding case law, where a court has to actually decide a question to resolve a case. So, prior to 1983, there had never been legislation which sought to make abortion more available than it was under the Events Against the Person Act 1861. Therefore, there was never a case in which the courts had to decide whether there was an implied right to life of the unborn. There were instead these observations. But nonetheless, there was a body of opinion prior to the Eighth Amendment that legislation which sought to introduce abortion or to enable abortion or decriminalise it in circumstances broader than the 1861 Act would have been unconstitutional. The issue of whether those judicial statements were correct fell by the wayside once the people adopted the Eighth Amendment. There was now express provision in the Constitution providing for the right to life of the unborn. Now, this obviously is the backdrop against which you, the Assembly, will have to start to address what options are available to you. You've been asked to consider, to make such recommendations as you think fit, and to report to the Houses of the Oireachtas on the Eighth Amendment. Obviously, it's a matter for you how you discharge that remit. Nothing that I say here is intended to suggest any limitation on the range of options available to you. But what I do want to do is to assist in considering the implications of some possible recommendations. And in that regard, there are three obvious top-level options which the Assembly may wish to consider. One will be to retain Article 43.3 in its present form. And you have heard over the course of your deliberations a great deal of information regarding the legal interpretation of this provision, regarding its legal effect, and you know that the consequence of the provision is that the level of protection provided to the unborn by the Irish Constitution is extensive, and that the power of the Oireachtas to legislate in respect of abortion is limited by the protection afforded to the unborn. And you have considered the legal, medical, and indeed practical consequences of that. Those legal, medical, and practical consequences will continue to prevail as now in the event that the first possible option, retaining the article in its present form, is what finds favour with you. But there are two other options that you will wish to at least reflect on: repealing Article 43.3, and by that I mean simply repealing it and not putting anything in its place, or amending it. And I don't believe that the second and third of those options have been considered with you yet, and it's for that reason that I propose to focus my comments on those. So, if Article 43.3 were to be removed from the Constitution and nothing put in its place, what would the consequence be? And in that regard, there are a number of important questions that present themselves. Would the position be that the Oireachtas was totally free to introduce whatever abortion laws it believed were appropriate? Would there be any constitutional limitation on the powers of the Oireachtas in that regard? If there was such a constitutional limitation, where would it derive from, and what would its effect be? What about the right to life of the unborn, which some judges had suggested before 1983 was impliedly protected by the Constitution? If the express right to life of the unborn were removed through the repeal of Article 43.3, would that implied right in some way revive? Indeed, were the judges who expressed that view, which again, to repeat, were not deciding binding case law and not making law, but were the judges who expressed that view correct at all? What about the right to privacy and autonomy of the woman? If the express right to life of the unborn is removed from the Constitution, then is there a prospect that the courts would decide that there was now no constitutional justification for having restrictions on the ability, entitlement of a woman to an abortion, save in limited circumstances? And you will be aware from earlier papers that in other jurisdictions, most noticeably and controversially in the United States, the Supreme Court there derived from a right of privacy, which, as the Irish Supreme Court has done, was found to be implied in the federal Constitution of the United States. The Supreme Court there found that there was a right to an abortion, frequently referred to as the right to choose. Is there a prospect that the repeal of the Eighth Amendment would have that effect? Now, the resolution of those questions depends on many of the general principles that I outlined at the start of the paper. Essentially, it comes down to this. If the Eighth Amendment were repealed, and if nothing put in the Constitution in its place, and if the Oireachtas introduced legislation allowing for abortion in a broader range of circumstances than is presently permitted, two prospects present themselves. One is that those who believe that the legislation allowed abortion too freely would come to the courts and say, well, the Eighth Amendment may have been repealed, but remember, there was an implied right to life of the unborn in the Constitution before 1983, and we believe this legislation, broadening the circumstances in which abortion is permissible, we believe that this legislation violates that implied right to life of the unborn. Or alternatively, there may be those who will say, well, this legislation does not allow for abortion in a sufficiently wide range of circumstances. This is an impairment of the right to privacy or decisional autonomy, or possibly the right to bodily integrity of pregnant women. At present, cases of either of those kinds would fall to be resolved by reference to the text of Article 43.3. There is a formula of words in that provision by reference to which the courts can, and as you know, have determined the balance between the right to life of the unborn and the interests of the mother. But if the provision is taken out, how will that balance be fixed, and by reference to what considerations? This is a matter on which different people have different views. And I think that one can reduce the possible consequences to three broad headings. The first would be an interpretation whereby the form of abortion legislation after repeal of the Eighth Amendment would be exclusively a matter for the Oireachtas. And on this version, the argument would be as follows. The people, were they so to do, have voted to repeal the Eighth Amendment. By doing that, they have made it clear that they do not want the Constitution to regulate abortion, and they want the decision as to when abortion will and will not be prohibited by law to be made by their elected representatives, not by the Constitution. And lawyers arguing for this construction or this outcome would say that the courts must give effect to the decision of the people to repeal the Eighth Amendment by allowing the Oireachtas a broad remit in formulating and passing laws regarding abortion. And the decision of the people, having had an express right to life of the unborn in the Constitution and decided to take it out, the decision of the people could only be that they do not want there to be any such constitutional regulation going forward. And were that view to prevail, two things would follow, I think, from any repeal of Article 43.3. First, the Constitution would not protect any constitutional rights of the unborn, or at the very least, whatever residual protection there was would not prevent the introduction by the Oireachtas of laws which it deemed appropriate enabling or regulating abortion. And secondly, on this view, the Constitution would not protect any right of a woman to an abortion. On this view, any form of constitutional regulation would have to be expressed by the people. So, if that view were to be correct, the consequence would be that following the repeal of Article 43.3, it would be solely the Oireachtas that would decide the form of abortion laws. The Oireachtas could decide to leave the law exactly as it is in the 2013 Act. It could make abortion available in a wider range of circumstances than is currently the case, or indeed it could limit further the circumstances in which abortion is available, even beyond the circumstances defined by the 2013 Act today. The point being that that decision would have been moved from the Constitution to the Oireachtas, the elected people, representatives. So that is one view as to the effect of the repeal of Article 43.3. But there's a second view, which would be this. Others will say, well, all the people have decided to do is to repeal Article 43.3, and different people who have voted in favour of that have done so for different reasons. Therefore, the argument would run, the implied right which the unborn had to life under the Constitution before 1983 revives. If the people had wanted to remove any implied right to any implied right to life of the unborn, then on this argument they should say so. And that if they don't say so, the presumption is that they are simply taking the constitutional position back to where it was in the early 1980s, which, on this argument, included an implied right to life of the unborn. So, if the Eighth Amendment were to be repealed, and if this argument were to find favour with the courts, the consequences would be most uncertain. It would be said that the Oireachtas, in introducing legislation to allow abortion, would have to have regard to the implied right to life of the unborn, and in some sense balance this against any judgment made by the Oireachtas that abortion should be more freely available. And that could limit the right of the Oireachtas to legislate freely to make abortion lawful in a broader range of circumstances than is presently permitted. One possibility in this circumstance is that the courts would try to strike a balance to say that the people clearly did not want the regime as provided for in Article 43.3 to continue, that's why they repealed it, but that not having stated that the unborn were to have no rights, that the consequence is that the courts should engage in a balancing exercise. The courts should try to conduct a balance between the circumstances in which abortion legislation should be permissible and the continuing right, if such it be, of the unborn. And there's then a third body of opinion, which would operate something like this. In Article 43.3, there is an express right to life of the unborn. That is the consideration in the Constitution which justifies the criminal prohibition on abortion. If you remove that provision, the consequence is that there is no countervailing circumstance to balance against the right to privacy or decisional autonomy, or for that matter, if it arose, bodily integrity of the woman. And therefore, those rights would generate what is in effect described as a right to choose. And if that were to be correct, then the entitlement of the Oireachtas to the entitlement of the Oireachtas to legislate restricting abortion would be itself significantly constrained. So, those are the three options. Different lawyers have different views as to which of those outcomes is the most plausible. I personally think that the first is the most likely. I think that it most likely, were the amendment to be repealed, simpliciter, that the courts would decide that they should give effect to the view of the people, and that the consequence of the repeal was to extract, the consequence of the repeal, is to extract abortion regulation from the Constitution altogether. But that is only a personal view, and there are others who have different views. None of the positions that I've just outlined is impossible. Some are more plausible than others. And what it means is that if a proposal to repeal the Eighth Amendment is put to the people and no further amendment is provided for, there are likely to be different views expressed as to what exactly the constitutional position will be following such repeal. There are many who would be happy to have such decisions entrusted to the courts. There are many who feel that they would wish a greater certainty, and those are some of the issues with which you will have to grapple. But remember also, and this follows from the papers you heard earlier today, repeal has implications potentially for issues other than abortion. You've heard two papers on various issues related to the Eighth Amendment, emphasising, I think, the uncertainty of the law, and in particular as to whether this article in the Constitution has implications outside the arena of abortion regulation. If Article 43.3 does imply more rights for the unborn, other than the right to be born, and if Article 43.3 does affect medical decision-making, these areas of law would also be affected in some way by the repeal of Article 43.3. If the effect of the repeal is to widen the circumstances in which abortion is available, greater legal attention would have to be paid to the issue of who gets to decide whether to have an abortion, whether the mother or both parents or the parents of a pregnant minor. And this picks up on a number of the issues you've heard discussed earlier. So, those are three possible constitutional implications. As I've said to you, different people have different views as to which are the most likely, which are plausible, but it's hard to say that none is impossible. And that leads to the next general option, which is not repeal of the Eighth Amendment, but to an amendment of it. And here there's, I think, a very broad range of possible amendments that one could conceive. But it seems to me that there are perhaps four principal types of amendment and one option related to or similar to amendment, and they're as follows. The first, of course, is to amend so as to increase the constitutional protection of the unborn, and that's an option which one would adopt if one felt that the protection provided by Article 43.3 in its present form was not adequate or not sufficient. The second would be to amend so as to allow more freedom to the Oireachtas to permit abortion by law, but only to do so in defined circumstances. And under this option, what the people would be doing were they to proceed in that way would be to maintain the right to life of the unborn in some shape or form within the Constitution, and thereby continue to limit the power of the Oireachtas to legislate in the area, but by defining within the Constitution a broader range of circumstances in which abortion is permissible, it would become possible to allow the Oireachtas, if they decided so to do, to alter the substantive law in the 2013 Act. And obviously, just how broad a range of those circumstances, that range of circumstances would depend on the assessment of whether, and if so, when and in what circumstances abortion should be permitted. But what is important to emphasise about this type of amendment is that the Oireachtas would not be free to define the circumstances in which abortion is permitted. They would be specified in the Constitution itself. There's a third option, which would resolve the uncertainty attending the effect of a repeal of Article 43.3, and that would be to remove Article 43.3 in its present form and to replace it with a provision that expressly removes the right to life, or any rights for that matter, of the unborn. So on this version, what you would be doing is saying, the people would be saying, we want not merely to take out Article 43.3 in its present form from the Constitution, but we also want to make it absolutely clear that any suggestions in previous judicial statement that there were implied rights of the unborn, which might themselves limit the power of the Oireachtas to introduce abortion legislation, that we do not believe that that should be the constitutional position. So that, as it were, an express provision removing the right to life of the unborn would achieve that, or be designed to achieve that objective. A second, not unrelated but different option would be to state that the Oireachtas shall have full power to decide on the scope of permissible abortion, and there are various formulae within the Constitution where certain types of legislative activity are immunised from review by the courts. No law passed by the Oireachtas allowing for abortion shall be inconsistent with any provision of this Constitution, and so forth. But the objective being to expressly state that we are consigning exclusively to the Oireachtas the function of determining abortion law and policy hereafter. And then finally, this option. I've seen it suggested that if the government published legislation at the same time as a repeal of, or as a referendum for the repeal of Article 43.3, and if the people were to vote to so repeal the provision, that the courts might decide in future that abortion in circumstances other than those provided for in the published legislation was not permissible, and perhaps a possible outcome, in my view, to say the least, it's not certain that that could occur. But the same effect could be achieved by repealing but providing in the Constitution itself for a detailed law regulating abortion, which itself could not be amended without referendum. That's unusual. It's a cumbersome form of constitutional amendment. It creates various but not insuperable practical difficulties, but certainly legally it is possible. So I hope you find those thoughts of assistance in your considerations.
Very good. We'll move on now to the roundtable discussion. You'll have until 1 o'clock when we will have our questions and answers session. Have we any prompts? We have certain conversation starters, as I say, prompts, and they're up on the screen. And also, if I could say to the viewers outside this room, I would strongly urge you to have regard to Brian's paper. It is very, very helpful. Thank you very much, Brian.